Okay, anyone who's recording, we should do it now. All right, good evening, everyone. Welcome to our White Collar Support Group Tuesday night speaker series. Tonight, we have a very special speaker who we are so honored to have, Rachel Barkow. She has an incredible background. Among other things, she was a member of the U.S. Sentencing Commission. She was a U.S. Supreme Court law clerk. She's a law professor at NYU. And a practicing lawyer, I think, but certainly a lawyer. And I'll read her bio in a second. But I want to let you all know that this is sponsored by Progressive Prison Ministries and our support group. We meet on Monday nights at 7 p.m. Eastern every week. We've been doing that for over 9 years now. In fact, last night was our 450th weekly meeting. So it's incredible that we've been able to be around this long. And as anyone in criminal justice knows, it's hard to get any organization to last for 3 meetings, but we have unanimity of purpose. We're here. We are a support group, and we know our mission. But we do have some incredible initiatives that we've launched this year, including the Right to Banking initiative. And we also have a pardons and expungement initiative, which, of course, is in the news a lot now, and more on that to come. So if you want more information, or if you are justice impacted, or one of your loved ones or colleagues or clients are justice impacted, you can get more information on our website. That's prisonist.org. That's prisonist.org, prisonist like, and you can just find all our information there and fill out the form, and we will get in touch with you and help you or your loved one through your issues. I also want to announce that we have the next speaker that I can officially announce is Lewis Reed, who's going to be our speaker on April 8th, on Tuesday, April 8th. And Lewis is a criminal justice advocate. I've known Lewis for a long time because I did criminal justice work in Bridgeport, Connecticut for about 10 years. And Lewis is from Bridgeport, and he has an incredible story to tell. And of course, he's been on the national stage now for quite a few years. And more of that to come. Check our emails, check our website, and more on Lewis. And Aaron, I am not going to announce you as next month's speaker yet until we lock that down. But Erin Fry is here with us in the audience, and I'm pretty sure she's going to be our next month speaker. So let me introduce Rachel Barkow. Rachel is the Charles. Oops, can't read this. Charles. Oh, help me here. Hold on, I'll get it. I'll get it. Charles Seligson Professor of Law at NYU School of Law. She also serves as the faculty director of the Zimroth Center on the Administration of Criminal Law at NYU. She served as a member of the United States Sentencing Commission from June 2013 to January 2019. She's the author of Prisoner of Politics, Breaking the Cycle of Mass Incarceration, which came out in 2019. And she has a new book, which we are going to plug here tonight, I promise you. And we're going to put the link in, and we'll also put the link in our show notes for her new book, which I'm going to let her tell you about, but I will put the link in chat as well. Rachel's recognized as one of the country's leading experts on criminal law and policy. Professor Barkow teaches courses in criminal law, administrative law, and constitutional law. In 2013, she was the recipient of the NYU Distinguished Teaching Award. The law school awarded her its Podell Distinguished Teaching Award in 2007. And after graduating from Northwestern University, she attended Harvard Law School, where she won the Sears Prize. She served as a law clerk to Judge Laurence Silberman, the DC Circuit Court, and Justice Antonin Scalia on the United States Supreme Court. So, Rachel Barkow, we are so happy to have you here with us tonight, and you have the floor for about a half hour, and we'll follow that with a Q&A. So, welcome.
Oh, thank you. Thanks, everybody, for having me. I see a few familiar faces out there. Hi, Bill. um, so I thought what I would do based on what Jeff told me you might be interested in is kind of do some highlights of some topics. And then feel free to ask questions if you want me to go in greater detail about any of them or bring up something that I didn't already. So I thought I'd start with sentencing. And as Jeff mentioned, I was, a way back member of the Sentencing Commission. And that's obviously a really important body. I really should probably just hand this over to Doug Berman to talk more about too. But the Sentencing Commission has done some, pretty great things, I think, in the last several years. I think it's been an outstanding source of some of the, frankly, the best things to come out of the Biden administration. They, for example, drew a distinction between people who had no criminal history whatsoever, what the Sentencing Commission calls people with 0 points, versus people that had what's known as 1 point, because they were really different kinds of people, and they allowed the 0 pointers to get reduced sentences as a result, which I thought was a really great reform that we unsuccessfully tried to get passed when I was there. So they did it. And they, for example, no longer allow people's sentences to be increased on the basis of conduct for which someone was acquitted. So, if the jury acquitted you of something, somewhat inexplicably previously, the judge could still sentence you to a higher sentence on the basis of that conduct, but the Sentencing Commission has said that's not okay anymore. So they did some really great things, and I bring it up because the personnel of the Sentencing Commission is in flux. So, to the extent you're looking ahead and trying to figure out what are some changes that we're going to see now with the new Trump administration, and Doug, you correct me if I'm wrong on this, since now I know you're here. But my understanding is there were two commissioners that were up for renewal, Judge Horn and Judge Gleason. And so one Republican, one Democrat, and they were put forth before the Senate, and the Senate did not do anything with those. So the nominations were returned, which means that President Trump will have two, and that's going to flip the composition of the commission, because presumably what he's going to do is he's going to appoint two Republicans. So you'll have four Republicans on the commission instead of what we have had for a little while now, which was four Democrats, three Republicans. So that's gonna shift what the Sentencing Commission looks like. And usually when that happens, it shifts what the Sentencing Commission does. They just have a different set of priorities, and I expect that means on the white collar crime front, probably not going to do a lot in the way of making things more lenient. I don't know if they'll do something to make things harsher. Like, you really never know with what the commission is going to be up to. But it will change the agenda, because we have seen in the last couple of years they have really emphasized finding ways to reduce sentences. That's been the hallmark of this commission that has existed for the last several years, and then that will be no more. I think it's safe to say. We'll see who ends up. I haven't heard any gossip or rumors as to who the two people might be to fill those spots. I don't know if anybody else has. We could talk about it if you have names, but I think whoever it is, it's a pretty safe bet to say that the commission is not probably going to be a source for much reform for the next couple years. So that's kind of the sentencing front, really, unless Congress does something, which is certainly possible. I haven't really heard that there was anything in the offing related to any white collar adjacent kinds of issues. You never know, but I haven't heard anything yet. So that's kind of what I had on sentencing. I think the main story is the commission. The next topic I thought I would just highlight, and this one I'm going to spend more time on. This is something that I've paid a lot of attention to. And because of the commission's composition changing, I suspect clemency will be the space where you're more likely potentially to get sentencing reductions, relief, or at least it's an avenue that might be. Although I'm not super optimistic. So let me give a recap of what just happened on the clemency front. This one I honestly could spend all my time on. So I do a lot, I should say, just because it wasn't necessarily highlighted in my bio. So clemency is one of my areas of expertise. I've been working on this for a really long time. And really pushed the idea when I was a staffer for the Obama campaign, pushed the idea that if, then, running for president, Barack Obama, if he were elected president, that he should seriously consider using the clemency power for criminal justice reform because he was likely to face a Congress that wasn't going to be super helpful. And why don't presidents use clemency more was kind of the claim. So, I wrote a little campaign memo, and I was part of a group of people who really kept pushing President Obama to do that. And as many of you may know, he did have a clemency initiative. And there were lots of great things about that initiative. And certainly a lot of deserving people got their sentences reduced. But a lot of deserving people were left behind. So, it was a mixed bag. It was a flawed process, I guess is what I'll say, because what President Obama did is he did decide in his second term, by the way. The first term was, not super promising, which is very typical. A president thinking about reelection doesn't see clemency as like the world's greatest thing for reelection. Usually, we'll talk about Trump in a minute, but at least President Obama was a more traditional president that way, and really put it off till his second term. And there were several of us who really urged him to fix the process, because the current process, which may also be of interest to some of you, is if you want to get either a sentence commutation, so a sentence reduced, someone currently serving one, or a pardon. So you would like, and at the federal level, that's kind of what you need to do to clear your record is get a pardon. There's no expungement process at the federal level. So if you're convicted of a federal crime and you want a pardon, you have to get the president of the United States to give it to you. And what you need to do is you file a petition with the pardon attorney, and that's an office within the Department of Justice. And it'll go to someone who works for the pardon attorney. They'll review your application to make sure that you fit the criteria. For example, if you want a pardon, you have to have been out and living crime-free for 5 years is the kind of general standard. And commutations, it's a higher bar, kind of. They typically see that as a more extraordinary thing, although recently, they've been looking pretty closely at people who are serving sentences that they wouldn't get today, for example. But whatever the criteria is, that lawyer in the pardon attorney's office reviews your application. If they think there's something to it, it would go on to the pardon attorney. If they think it's promising, it goes to a lawyer in the deputy attorney general's office. Only if they think it's promising would it then go to the deputy attorney general. That's the deputy attorney general of the United States, who has a pretty busy portfolio. They're in charge of the whole criminal division in the Department of Justice. So, I always have this image in my mind, like that they just have like a million terrorism and a gazillion things going on. And then like these pardon petitions arrive. And so usually they just sit there. And traditionally, they never leave the deputy attorney general's office. That's been a huge problem. And usually they don't even land there, because part of the process in the pardon attorney's office is they go back to the prosecutor's office that brought the case. And they say, hey, what do you think? Which takes a kind of monumental amount of cognitive separation, I think, for a prosecutor to say, although I brought this case originally and, pursued it to its fullest extent, let me take an objective look now and see if maybe I shouldn't have done that and this person should get a break. Most prosecutors, as human beings, aren't very good at that. So most of the time they say no, no, there shouldn't be a commutation, shouldn't be a pardon, and they're pretty oppositional. But if somehow you can get through that and you make it to the deputy attorney general's office, you're competing for time with the deputy attorney general, and you have to hope that they agree, it should be granted. If somehow you make it through those 4 layers of review at the Department of Justice, your petition goes over to the White House counsel's office, to a lawyer in the White House counsel's office. And that office is also a very busy place. So those lawyers are doing all the nominations. They're doing any lawsuits against the president. They're depending upon how the president is allocating authority, they may be exploring big constitutional questions, what the president can and cannot do. It's a busy office, and again, you're competing for time. So when it gets to the White House counsel's office, the petitions often just sit there and nobody does anything with them. But if they make it through that lawyer, the lawyer looks at it, decides, oh yeah, okay, DOJ said it's a good idea, I think it's a good idea, then it would go to the White House counsel. So that's the White House counsel, who again has a million things going on. And then if the White House counsel thinks it's a good idea, then it would go to the president. Okay, so that's been the process for a while now. I hope by just explaining it, you realize how ridiculous it is. Like, I don't think anybody would design a process that looks like that. I don't think anyone would decide, let's ask the prosecutor what the prosecutor thinks. I don't think anyone would say, let's have 6 layers of review before it goes to the president. And by the way, this was all with a paper file. People were doing this with like an actual folder. I think they finally just shifted that, but up until just a couple years ago, this was all like the paper file was moving from office to office. So that was the case when President Obama was in office, and we said that is lunacy. And if once he decided he wanted to kind of do this initiative, we had said, you have to change this process. This will be terrible. Don't do this. It's bad, bad, bad. He didn't listen. He kept the same DOJ process. It was a mad scramble at the end. And as a result of that, a lot of people got left behind. That really bothers me. It really bothers me when people are left behind because of bureaucratic incompetence, and they met the same standards as the other people. But that was what happened. So, several of us, I usually do this with Mark Osler, who's a professor at St. Thomas. We kind of have been beating this drum for a very long time together. We tried again. And we tried in the first Trump administration because, as some of you may remember, Jared Kushner was very interested in criminal justice reform because his father had served time. And so this was something personal to him, and he was really into it. And so what we had been told was that there was a lot of interest in the White House for various sentencing reforms and clemency reform. So I attended a meeting at the White House. It was awkward. It was presided over by Jared Kushner. I sat next to Ivanka Trump, and there was a cast of characters there that included Kim Kardashian. It was a really odd meeting, but the point of it was supposed to be, let's reform clemency. And it was, he had, at that point, he had, from Kim Kardashian had recommended a clemency grant for Alice Marie Johnson. And so he was kind of getting recommendations from the people he knew. And so some celebrities had taken up the cause, for example, of Alice. But most of the people that got his attention were people that he knew of because they were his cronies. So, he, in his first administration, President Trump basically didn't use that Department of Justice process. It was like 20 people got through the DOJ process. And on the other, he had a very low grant rate. But of the people that got grants, it was like 20-ish went through DOJ, and like 200 just went directly through some other channel. So that channel was often Fox News. Fox would tout somebody, or it would be someone that worked for Trump, your kind of Manafort's, Roger Stone's, Sheriff Joe Arpaio. There were a couple people who had been convicted of war crimes that now Defense Secretary Hegseth had touted their cases on Fox, and those were grants. So that was another 4 years of a clemency process that I will call broken, because you still had people that filed their petitions at DOJ. No one looked at those. And the president just did his own thing, and he did what he wanted. No vetting. And because there was no vetting, I have to say, there was actually some, fairly serious reoffenses among some of the people that he granted. There have been some articles recently about that in the news. So that gets us to President Biden. And again, Mark and I, we're out there saying, okay, you really got to fix this process. You need to do something. This has been broken for a while. We have past presidents saying it's a terrible process. George W. Bush said, oh my gosh, fix this, Obama. Like, everybody had said, fix this. And President Biden had promised to do that. When he joined this task force with Bernie Sanders. I don't know if you all remember, but it was the Biden-Sanders task force. It was really a way for President Biden to try to get some voters on board that were Bernie supporters. So they formed this task force, and they found areas of compromise. And one of them was, yes, let's reform the clemency process. Let's create like a separate advisory board that's not the Department of Justice. We'll rule out all these layers. It'll be a good process with vetting, and it'll be objective, and people will get equal treatment. And that was in this document. It never happened. President Biden just really paid no attention to clemency, despite lots of us urging him to do so. We tried. We really did try. We tried meetings. We tried op-eds. we don't have a lot of grassroots organizing, but we did try to work with organizations that do. He did nothing. And so he did not reform the process, and he really didn't grant any either. His grants for the first 3.5 years, he gave a couple grants to people who were already out under the CARES Act. So they were already on home confinement. And what he did was just say, okay, we'll say time served with your home confinement and you're done. But that was pretty much it. He didn't really let anybody out early from a prison sentence. That was just not what he was doing. So that brings us to the fall of this year when, he's a lame duck. Mark and I thought, okay, we're going to make one last push. We published an op-ed in the New York Times that got some attention that was like, look, President Biden, your legacy is going to be defined in part by what you do with your clemency power, and you only have a little bit of time left. And so we had a list of things that we thought were still doable in the time that was left. In an ideal world, he would have done far more, but in the time that was left, there were a much more limited category of things he could do. So we argued, top priority, grant the petitions that the Department of Justice has sent over to the White House. Like the people who followed the rules, filled out their petitions, got a positive recommendation through that gauntlet of 6 layers of review. You have to grant those. Like, how could you not grant those? That should be the first thing you do. Like, it shows your respect for the Department of Justice. It shows that you actually care about a fair process for everyone. That was the first thing we said. Then we said, also death row, the federal death row. President Biden had indicated he was against the death penalty. And so, we pointed out this was a chance to really show that you have a principled opposition to the death penalty by commuting the sentences, because if you don't, then what's going to happen is if President Trump wins, we wrote this in September when we didn't know, he's going to execute those people, because that's exactly what he did after the Obama administration. Just all they did was a moratorium, no commutations. President Trump came in and had just a really very rapid set of executions. And that was going to happen again. The campaign made it clear. Project 2025 has made it clear that that's a priority. So, it wasn't like it was a secret. So we said you should commute the people on death row. And then we said all the CARES Act people should just categorically say commutations. Like, just do it as a categorical matter. They're out, they're leading law-abiding lives. Like, you just decide that is something that they don't need to go back to prison. And then we said, think about marijuana as a category that merits being treated differently, because so many states have it legal now, and we still have so many people serving long terms of incarceration for that. And we thought that's like the easiest batch of stuff you could do in the time you have left. So he obviously didn't act on that right away and until the election happened, which I understood, actually. I'm sympathetic to that. Like, wait and see. You don't want to screw up the election and think that something that you did on clemency would hurt your vice president. So once Trump won the election, what I had thought was going to happen is we were going to see him do some number of those things. And I thought the first thing he'd do was the first thing we said, which was just grant all the petitions that the department has looked at, because they did such a careful job. And for the life of me, I cannot tell you all why that did not happen. There was a Wall Street Journal article this weekend where I will confess I had some inside information about this that it's been very hard to like point to that this is true, but now I can actually tell you, because there is an email that the pardon attorney sent to U.S. attorneys around the country that was leaked to the Wall Street Journal, I guess. And the Journal reported that the pardon attorney told all those U.S. attorneys, hey, I sent over petitions to the White House, and he didn't grant them. And the reason that she sent the email was because what the president did do in his final weeks in office is, so he did commute federal death sentences. He commuted 37 out of 40. Mark and I had argued, you got to do them all, because you say it's principle. The principle should be the state shouldn't be allowed to kill people. That was our claim. President Biden didn't do that. I mean, the 3 cases that he didn't grant, they're pretty awful cases on their facts. I'm not saying that they aren't, but we thought it would be better to just do a principled thing. But he did do 37 out of 40. He did do all the CARES Act people, commutations for them. And then he created his own category that he did on the fly, which is, he said nonviolent drug offenders who would be sentenced differently today but he didn't ask the pardon attorney to help him or vet them or do anything. He just did it ad hoc. I guess he had some lawyers in the White House trying to do it, so it was kind of a scramble at the end. And what ended up happening, some of you may have seen these news reports, there are some people that got grants that have some really awful things in their backgrounds that would never make it through that DOJ vetting process, child sex offenses, violent sex offenses, like bad stuff that normally doesn't make it through the DOJ process, and no indication that the person had been rehabilitated or changed because there was no individualized vetting. It was really just like I think they just wanted big numbers. So they granted those in the waning days, and some of the cases when the U.S. attorney's offices found out, they were outraged. Like some of these were, as I said, really pretty serious things, and they didn't seem to meet the criteria that President Biden had said, which was these nonviolent drug offenders, because there was a lot of violence in their past. So when the pardon attorney sent the email to the U.S. attorneys, it was basically to say, don't blame me. I didn't vet these. No one asked me to vet these. I sent a different stack to the White House that were never granted. So that's all public. That's what we know happened at the end. And you, of course, know the high profile cases like Hunter Biden getting a grant, and, two Biden siblings and their spouses, which is a whole separate category of things we could talk about if you want. But the takeaway from all that I think is just, it's just another example that this process is broken. And that if you're just a regular person who wants to just file a petition and get it looked at and have it fairly evaluated by a person, we have now had 8 years where that will not happen for you. And I just think that's irresponsible in a government that is dedicated to equal treatment of people, any notion of rule of law and treating people similarly. I think it's awful. And I think it's a really shameful legacy on the Biden administration's part that they couldn't grant those petitions that got that individualized review. Then this was like the most exciting month in the history of clemency ever, because then President Trump comes in, and on day one, he does the same thing. He gives a blanket pardon to all the January 6th participants. No vetting, no individualized review, no looking like, hey, what did they do on January 6th? Were they just convicted and charged with trespassing? Or were they someone that hit a police officer with a steel pole? He didn't care. They were all treated the same. They were all given a pardon. And there was also no vetting about any other criminal activity that those people had engaged in their past, or that they could be subject to charges with. So now almost every day there's a news story about one of the January 6 participants being charged with some other crime. Again, that's what happens if you're going to do a categorical grant with no vetting, is you're probably going to have more cases like that. President Trump also gave a pardon to the founder of Silk Road, which was that dark website where you could buy and sell drugs and weapons and stuff, and was built on crypto. Ross Ulbricht, he got a pardon. His case had been championed by a fair number of people. And some people who had been convicted of blocking an abortion clinic. So so far, that's been the Trump grants. No vetting, no nothing. They're just kind of what he's going to do. And I will say, given that he granted a lot of political cronies and allies in his first administration, I think it's a fairly safe bet that he is going to do that again. And because of the Supreme Court's immunity decision, it would be very difficult, should there be any kind of quid pro quo or untoward idea of an exchange for something, or it'd be very hard to ever make a case about that, because of what the Supreme Court has said is privileged communications between the president and the lawyers in the Department of Justice. So, if you want to put on a really dark perspective, if you had somebody that was inclined to want to use the pardon authority in exchange for other things, it's kind of open season on that. So all that's to say that when it comes to the clemency front, I'm pretty concerned that the next 4 years are going to be not great. So anyone who wants to get relief that way, which, as I said, is still really important because, at the federal level, you have no other avenue to get your record cleared. There's no expungement. And I think getting sentences reduced these days is really tricky. Which brings me to my third topic. which is compassionate release. That is still a good avenue, I think, in terms of going to a federal judge. That in the last several years, that was something that President Trump does deserve credit for, I think, because in his first administration, he passed the First Step Act. And one of the things the First Step Act allowed people to do is previously, if you were incarcerated and you tried to get compassionate release because you were sick or you had a child who was being cared for by somebody who wasn't incarcerated, and then that person passed away and you were like the last surviving relative, but you were incarcerated and you were like, can I please get out now? You'd have to go through your warden in the prison, and the wardens at BOP pretty much never gave anybody approval. So there was all kinds of inspector general reports about how bad the process was. And one thing the First Step Act did was make it so you no longer had to go to your warden. You could just file directly with a judge. And that made a sea change in compassionate release. And then the other big change was that when you ask for compassionate release, in addition to those like health effects, care of a minor child, the court started recognizing that it was a grounds for release if you had an egregiously long sentence that wouldn't be given today, kind of a real outlier sentence. The Department of Justice hated that, still hates that, but the Sentencing Commission upheld it and had said that's a grounds. I suspect that's still going to be in flux, whether or not that goes away or there's a shift at the commission. But for right now, you can go before a judge and ask for a compassionate release on that basis. All depends on who your judge is. Lots of variation around the country based on that. So that's my little quick take on compassionate release. I'm going to do one more topic, Jeff, and then I'll kind of take any questions people has. So the last one was just you had flagged, Jeff, just the changes that are currently happening at DOJ and just kind of in general, and if there's any implications of that for white collar policies, sentencing, prosecutions. I've never seen anything quite like what we're seeing at the Department of Justice and the FBI. So what we know has been done for sure is that the high-level people in U.S. attorneys' offices, they're called the senior executive service, so they'd be like the supervisors in a U.S. attorney's office. They're typically people who've been there a while, so they have a lot of experience. They have basically, they're trying to get them all to leave, even though they have civil service protections. And so the first step in trying to get them all to leave is that they're reassigning them to work on immigration and deportation of people. And, that tends to be something that's not what these folks signed up for. Right? They went to the U.S. Attorney's Office because they wanted to kind of prosecute other things, and they didn't really want to work on challenging sanctuary cities. So they're trying to flush people out that way. Ultimately, I think what they're going to do is just fire them if they don't leave otherwise. And then that'll be challenged in court. The other thing that they've done is they have fired anybody who was in a U.S. attorney's office who was probationary. So that's anyone who hadn't been in the office for more than a year. They were all fired. Anyone who was hired to work, like my law students, unfortunately for them, for summer positions, all rescinded. All the people who were supposed to work in the Department of Justice Honors Program, which is supposed to be, a totally nonpartisan, just like, good law students around the country, rescinded. So all those offers have been rescinded. So the messaging about all this, I guess I would say that's pretty clear, is this administration is not that interested in experience. And not that interested, frankly, in like the traditional credentials of people. They're much more interested in loyalty to the president and a view that the president has complete control over prosecutions in the executive branch. I did a pretty deep dive into Project 2025 over the summer because contrary to the statements otherwise, that is the blueprint. That's what we're seeing. What you're seeing now is all in Project 2025. None of this is a shock. And it was explicit in Project 2025 that they wanted this new view of executive power that said, we used to have a traditional thought that, people who work at DOJ, we don't want to be a banana republic. We want those prosecutors to make decisions just based on the facts of the case, not about who the president is or what the president might want. They have a very different conception, which is that these are executive officers. They do the bidding of the president because the president was the person elected. And the screening that they did, there was a whole Project 2025 screening thing that they ran through the Heritage Foundation. and I didn't go completely through it. I just wanted to see what it was like. I got scared at a certain point in the process that I didn't know how far I could go down their website. But I can tell you that one of the questions on there is whether you agreed with the view that it's the president who gets to decide prosecution. Like that's a president that, and if you don't agree with what the president does, the president has the ability to fire you. So the view is very much of like a political view of prosecution that I think will influence certainly not just white collar cases, every case at the Department of Justice, because the kind of people who are going to be working there, certainly in the supervisory positions, are going to be people who hold the view that, hey, it's the president, it's president's call. He was the one that was elected, not me. So if the president is like, don't ever prosecute crypto for anything ever, we're never going to do that. If the president's like, you need to go prosecute these Democrats, we have to go do it because it's the president's call. So that's what I take to be the big shift. And then with the FBI, we're just going to have to wait and see how many people are going to get purged there. But it looks like they're planning on removing a lot of people. Anyone who was involved in January 6th is what it looks like they're going to do. And they've already done that. They already fired in the DC U.S. Attorney's Office any prosecutor who worked on January 6th prosecutions. Was removed. So, we're seeing all this in the beginning, and it's just this broader notion of making politics more part of prosecutions than we've ever seen in American history. So I that's kind of my overview of all that stuff. I'm happy to go deeper dive into any of it. If anyone wants to hear about my book, I just assume no one really cared about the book right now. Everything that's going on.
You should definitely pitch the book right now.
Yeah, but if in the course of all this you're thinking to yourself, "Oh my gosh, who could save us?" The book is a kind of dark take that don't rely on the Supreme Court for that, because they have a pretty terrible history when it comes to criminal justice issues. And the book is more targeted to mass incarceration and kind of how would you ever end up in America that you could be the most carceral nation on earth and have sentences that are so out of whack, and you could detain people pre-trial before they'd been convicted of anything. Like, how does this happen? How is plea bargaining so coercive and prison conditions are so bad? And the book argues that would only happen if you had a Supreme Court that just wasn't enforcing some constitutional rights and protections, because actually there are protections against all those things. And I go through 6 cases that I argue were wrongly decided, no matter how you approach constitutional interpretation. So if you go by the text, if you go by what the framers would have thought based on the original meaning of the words, or subsequent treatment of things. So there are cases that fail on all those metrics. And they really were just the Supreme Court capitulating to law enforcement. There's no other grounds on which those cases make any sense. They're your pure policy basis. And I argue it's bad policy, because that is really what paved the way for the government to really go full on with mass incarceration. So I guess if you think they can be overruled, it's a more optimistic tale. And that would require some of those originalists on the court to not be hypocritical, but actually to hold true to those principles, even when it involves criminal law and punishment as the subject area. So that's the book.
Rachel, thank you so much. I mean, I can tell you that the topic of pardons, expungement, clemency, compassionate release comes up. That's probably the number 1 or 2 topic that we're talking about every week in some form or another. And usually because every week we have people who are about to go through their pre-sentence investigations or their sentencings, or they're reporting to prison. And just so you know that, what we do is we kind of, we support them in all kinds of different ways, including tomorrow morning. We do have 1 or 2 people who are reporting to prison. So what we do is we share their cell phone numbers, and then we all text them while they're in the car driving to report. And so that's pretty special, really. And of course, we all want to accept responsibility for our behavior. That's not what this is about. This is just about helping people with a second chance and get hopefully elegantly through to the other side. So thank you so much for that. It was really wonderful. If anybody would like to ask a question or make a comment, please keep your question or comment to 1 minute, and then Rachel will reply, because we have a lot of people on tonight. So we're going to start with Bill and then Gabriel.
Oh, Professor, thank you. Um, I was just riveted. I just loved hearing you talk and speak about these things you're so knowledgeable about. I was reading this morning a review of your book on the Federalist Society website, and I don't know if you've probably seen it. And as I was reading through it, and I'm not a lawyer, I didn't play one on TV, but I was thinking that kind of your argument. Do you see a straight line between how the positions the Supreme Court has taken versus the aggressiveness of prosecutors in the types of cases they bring?
Yeah.
Because it just seems like, prosecutors, scare quotes here, but a new novel theory of whether it's honest services fraud or whatever it might be. Do you see a straight line between those two?
Yeah, so I did see the review. I have to admit to all of you that I got like a Google alert that said there was something on the Federalist Society page, and I was a little nervous because I wasn't exactly sure how they were going to take it. Because although the book is, as I said, it really does like, hey, if you're an originalist, let me just show you these cases are wrong. Like, there's no way like that. And when I say slam dunk history, I truly mean it's like slam dunk history. And so the review mainly focused on the first chapter, which was the Supreme Court case that dealt with pretrial detention. And this is going to answer your question, Bill, because for our entire history in America, up until the late 1960s, early 1970s, everybody agreed you could not incarcerate a human being who had not been convicted of an offense as a preventative for dangerousness. Like, not okay. Like, no one thought that was okay. If someone was a danger, maybe you could get them civilly committed and you'd have to do clear and convincing evidence. It's a pretty difficult process, as you may know, if you follow things with people who have various mental health issues and you try to get them civilly committed. But that's the process that we had. You could not just detain somebody before they'd been convicted, which makes sense because we have a presumption of innocence, right? And what happens at the end of the 1960s, early 1970s is Richard Nixon decides he wants to have that changed. And so he has his attorney general writes a law review article saying, oh, no, you're totally wrong about that. We could totally detain people. It's a terrible law review article. I have to tell you, it's not persuasive. There's no source. It's bad. But they pass legislation in the District of Columbia that allows you to detain people on the basis of dangerousness to kind of test it out in the courts. And it gets upheld in those courts. And then kind of to your point, Bill, as soon as that gets upheld, all of a sudden, attorneys in DC are like, okay, well, let's do this a little bit more. And then the federal government decides, well, let's push this further. Let's get a federal law where we could do it anywhere. And so they passed the Federal Bail Reform Act, way more sweeping than the DC law. It has things in there like you're presumed dangerous if you are just charged with drug crimes that have a certain statutory maximum. It's bonkers. Like, why would you just presume dangerous in there? But it basically, after that act is passed, and then the Supreme Court here's the case on it. And again, the briefs are like, you can't do this. We've never allowed this. It's totally unconstitutional. But the author of the DC law that Nixon put in place was Bill Rehnquist. He was working in the Nixon administration at the time. He wrote the DC law. Lo and behold, now Bill Rehnquist is the Chief Justice of the Supreme Court. When they hear Salerno, and surprise, surprise, Rehnquist is like, this is totally fine. I said it was fine. It's fine. So he writes the opinion in Salerno. And after they do it, prosecutors around the country are like, we're going to just go to town with pretrial detention. And states all around the country decide we're going to pass our own statutes that look like that and allow us to detain on the basis of dangerousness. So whereas before no state thought that was okay, once the Supreme Court says it's constitutional, it wasn't just like, well, it's constitutional, but that doesn't mean as a policy matter you should do it. But it did open the floodgates. And what you see is the increase in pretrial detention just skyrockets after that. And length of detention skyrockets. Before, when they first did it, when the DC law was upheld, they said, look, it's only going to be a short period of time. And even Rehnquist, in his opinion, was like, oh, there's this Speedy Trial Act. People won't be there very long. We have people in pretrial detention who are, it's like an average of almost a year. And they're in the same conditions that you're incarcerated in. I mean, I think any objective person looking at it, I really feel pretty strongly about this, which is why actually I was glad the Federalist Society reviewer was like, this chapter is very persuasive. This Salerno is really hard to justify. But jurisdictions found the Supreme Court upholding it, like they went to town with it. And that's true of all the other cases I talk about in the book. It's the same thing with Terry stops. So Supreme Court, police say, like, we need to be able to just like stop people on something less than than probable cause. We got to lighten that up for us. And so the Supreme Court's like, okay, even though the Fourth Amendment has never allowed us to do this, and no one has ever thought this was okay, and no one even makes an originalist argument that it's okay, the court's like, yeah, but it's 1968, and there's a lot of unrest around the country. There's a lot of cities burning. DC is burning. Like, I talked to a law clerk who was on the court when Terry was being debated and argued, and they said, oh yeah, you could see the smoke out the window. DC was on fire. And, people, it's a presidential campaign, and they're running with signs that say impeach Earl Warren because they're angry about decisions like Miranda and MAP. So the Supreme Court is on the ballot. They feel attacked. They feel like cities are under siege and crime is rampant. And they're like, we just have to give the police a win. So they decide Terry. Again, if you're just thinking constitutional law, not okay. Like, no one can defend that case. It's all, you can only defend it at pragmatism. But what happens after Terry is, again, it's the same kind of thing. This one would be police departments, though. They are like, wow, we could totally just start stopping people all the time en masse. And that's how you end up with something like the NYPD just engaging in hundreds of thousands of stops of people. That, if you're a black man in New York City, like, you're going to get stopped. It's bonkers. But Terry, once the Supreme Court says, oh, you can, it's not unconstitutional, they do it. So I do think there is that through line where when the court says something is okay, before, if there was a thought that, well, maybe we don't think it's lawful, but no one will talk about it, we'll do it anyways. Plea bargaining is another one of those. There's a lot of plea bargaining before the Supreme Court sanctions it. So I don't want to say like people don't do things even before the court says it's okay. But once the court says, actually, yes, it's okay, all that stuff increases exponentially. So there is a pretty strong relationship between those things. And obviously, if the court says something is not okay, then it declines. It doesn't always decline to zero, because I do think there's a lot of sub rosa stuff going on that, but it does decline. So yes, absolutely, I think that's true.
Thank you so much.
Thank you, Bill, for your question. Up next is Gabriel, and then Scott. Please keep to 1 minute.
Yes. Thank you, Jeff, for the opportunity. And thank you, Rachel, for sharing your wealth of wisdom with us. I have a question regarding the sentencing guidelines. I believe this is right in your wheelhouse. Specifically, it was Amendment 821 that went into effect November of 2023. Specifically, you may be familiar with this particular clause. It's Application Note 10B as it pertains to 5C1.1 sentencing. And I'll read it real quick. It's only one quick sentence. What it does, it now allows for a departure for cases where the applicable guideline range overstates the gravity of the offense, a departure, including a departure to a sentence other than imprisonment. That's the operative word, other than imprisonment, for those of us in white-collar crimes. I think this is the best kept secret. It's probably one of the greatest reforms to the white-collar crime sentencing than we're aware of. And I wanted to ask you, are you aware of any pushback regarding from the courts, from the district courts, opposing application note 10B under 5C1.1? Are you familiar with that?
No, I can try to look and see. I haven't heard, if Doug is still on and he has followed it, or I'm sure there's some white collar practitioners on here that might have tried to get relief under that, but I have not seen anything related to that, pushback or otherwise.
Okay, and then just real quick, second part, how do judges get schooled? How do they get briefed on these new changes when there's new amendments that come out?
Yeah, so if you're a brand new judge, it's the first time you've been appointed, they have this thing, they, believe it or not, this is what they call it. They call it baby judge school. I think that's so totally insulting, but that's what they all call it. So it's run out of the Institute of Judicial Administration. If you've been in DC, it's the building next to the Thurgood Marshall. It's the Thurgood Marshall building next to the train station. They run judicial trainings for new judges. So for a new judge, the Sentencing Commission always sends representatives from the commission to brief the judges on the guidelines generally and new guidelines. For existing judges, so judges who aren't going through the new process, the Sentencing Commission also does trainings around the country. And they will always offer, you know, so they do in-person trainings. Well, they'll go around they're amazing staff there. Like, they're outstanding teachers. They're great. And they go around the country and explain all the new amendments. And they also offer a lot on their website. So, you know, if the person doesn't go to the in-person training, every time there's new amendments, anyone can go look, and they have videos. These days they have a podcast. So they have a lot of materials on the website. So that's how judges could get it from the Sentencing Commission itself. And then my understanding is that, you know, a lot of courts also, the judges themselves talk about new things, you know, at their meetings. So district court judges might, I know when it came to the use of compassionate release for people who were serving long sentences, which was kind of a new thing. A lot of the district courts around the country, my understanding was they had like meetings to talk about, what are we going to do with these? You know, how should we handle these? How are you handling these? How are you picking and choosing? So sometimes they talk to each other. And internally to a district court, they decide things. But the kind of formal mechanism is the Sentencing Commission has those trainings and those materials that come out on the website. And then otherwise, you know, it's attorneys, you know, sometimes you'll see, like, through this commission's amendment cycle, what usually happens, a lot of the firms that do a lot of the white collar practice, in particular, frankly, do their little bulletins where they'll say, this is what the Sentencing Commission just did. You know, these are the new amendments. And here's what it might mean for you, you know. Contact one of our lawyers today. So there's a fair amount actually online that I think you would actually probably, like, for example, there may be some stuff on the provision that you flagged to see just how firms are interpreting it and what they're saying to their client base. But for the judges, it would be one of these trainings or the Sentencing Commission material.
Gabriel, thank you. Next is Scott, and Rachel's asked us for a hard stop at 8:15. So please stick to 1 minute. Scott, you next, and then you're up next, and Brent.
Sure. Rachel, I appreciate your time. We all do, as a matter of fact, I'm sure. You kind of skipped over some of the more questionable pardons in the last administration. What are your legal teaching opinion? What is your legal teaching opinion of pardoning somebody who hasn't committed a crime for unknown reasons?
Yeah, so the example that we have historically, that was the Ford pardon of President Nixon, was that's the blueprint for the pardon that was given Hunter. It's in the same language, it's formatted the same way. So you can't pardon somebody for future conduct. But what you can do is you can give a pardon for any conduct that's happened in the past, even though it hasn't been charged yet. And it, you know, I don't see any basis for anybody challenging that. I do think that's legal. It was what was done with Nixon, with President Nixon. He had never been charged. Oh, I'm sorry. Your sound. Oh, I don't.
Rachel, we just want to give you an opportunity to be able to answer. I apologize, Scott.
So I was just going to say, so President Nixon hadn't been charged with anything when President Ford gave him his preemptive pardon. And it's preemptive in the sense that it's just preemptive of the charging. Again, it's not about future conduct. And I, you know, it's very, I should say that the pardon power in the Constitution is in the Constitution. It's right next to the commander-in-chief power. And it's been, the Supreme Court has said repeatedly that this is basically an unfettered power. There's really no court oversight, no congressional oversight. So I don't think there's any basis for a legal challenge. The one area that hadn't been decided by the courts that I think is an open question that maybe the court would decide is whether a president could self-pardon. You know, that's an issue that is less clear. But in terms of giving a pardon to somebody else, even if it hasn't been charged yet, that legally is okay. Now, you could have questions about it as a policy matter, whether it's a good idea, you know, how you want to think about it, all fair game. But legally, I do not believe there's any basis for challenging that.
Thank you, Scott. Next is Brent, and then Gordon.
Rachel, thanks so much. I mean, you have given us a wealth of information tonight, just of all the things you've been involved in. One of the things that I was thinking about when you were talking is that I do a show. I've done like 160 interviews with people who are justice impacted, and one of the things that that comes up time and time and time again is the idea of, and you wouldn't think it was a big deal, but compassionate relief is a topic that is involved in a lot of situations, and it doesn't get a lot of coverage because they're always saying, "Oh my gosh, they're trying to get out." I was involved with a situation where my dad was in prison and I was in prison, and doesn't have anything to do with compassionate relief, but the information about people who are imprisoned, and when something goes bad for them, my dad went into a coma and had to get airlifted out. I found out about that through a visit because somebody knew somebody at Marion Prison. Within the prison system, I think it's really interesting how we don't have the ability for families to communicate with people who are impacted by the prison system within the prison system of people who are, we talk about compassionate release, but we also have issues that happen where you can't communicate with somebody unless somebody dies in prison, which is a crazy, crazy concept, I think. But it's not really ever talked about. But it comes up a lot because within the prison system, people have people in the prison system. I think of myself as like, how in the hell did that happen to me? But it did happen. But the other thing I was thinking about was and I appreciate you bringing up Richard Nixon, President Richard Nixon, because that's another topic that comes into so much into play, Rachel, with that we're able to bring so many people into to the system and then pressure them to do plea bargains in the jail and do their pleas in the jail by having the ability to have them contained with, I'm not sure what would have happened if they would have been outside and being able to do what they could do within that particular situation. But since I don't know if it was 1971, 72, 73, Richard Nixon drastically changed our system to say, it's okay, put them all in, doesn't matter. And then the Attorney General takes all the authority they need to pressure everybody. And then we get a 97% plea bargain rate in our system because we put a lot of people in.
Frank, you're running long.
Am I running along? I'm sorry. Rachel, I'm just saying, is there any way to take that back to a place where we could get to a normalization of that?
Yeah, so you're totally right about what happens when people are incarcerated pre-trial. They are more likely to plead guilty, and they have bad access to investigate their case. It really diminishes their ability to fight their case, and there's all kinds of empirical studies on that. So that's all backed up. That it's a boon for prosecutors when they can detain people pre-trial. My hope is that. So if Salerno can't be overturned, that's my dream. My dream is someone reads this chapter and like the Federalist Society is like, yeah, you're right. And, other organizations say you're right. And we fight this thing and it becomes like what, anti-abortion advocates did with Roe. You just start a campaign and you say it was wrong the day it was decided. It's still wrong. Overturn it. And we get it overturned. Admittedly, that's probably not going to happen, but it might be limited at least. If you could show that its roots were rotten at the core, maybe you get the court to start putting limits on how long can someone be detained pre-trial? How much do you have to show is a danger? So the other way you could do it is you could nibble back. And that would be in the courts. Again, you can try to do it in the political process too. That's much harder. It's hard to get sympathy. I do think though, there is political sympathy for the first scenario you described, which is the loved ones of incarcerated people. There's just a critical mass of people in that situation now. I mean, it's changed the entire political landscape. And so it's an organizational challenge to get those people together to push for change and, work with other political allies. But I actually think that can be done. I really do. I think that, making it easier for free phone calls, for example, was a campaign that a lot of people pushed for, so that you didn't have to pay exorbitant fees to even just talk to people who are incarcerated. And I think one reason why that's been changed in a lot of jurisdictions is you do have a critical mass of family members and loved ones who are like, this is insane. And they're a very sympathetic group of people, because although, politically it's hard to get the public when, you do the crime, do the time, and all that kind of simplistic notions that they have about people who commit crimes. No one's family member did that. Like, their children didn't do that. And so I have seen a fair amount of efforts now to try to pitch it as, don't punish the family, don't punish the kind of, I forgot the name of the movement that they have now that's about giving access to hugs for children. So and the idea is, how could you stop a child from being hugged? And you put the perspective of the family and the loved one, it's very persuasive politically. So I do think it's an organizational challenge. I'm not saying it's easy, but I'm actually pretty optimistic about some of that stuff. It's just a question of getting the public educated about it and framing it in the most sympathetic way.
Thank you, Brent. And it seems like it's a good time to give a shout out to Bianca Tylek at Worth Rises for spearheading the free prison phone call campaign around the country. Let's see, Gordon and then Michael, and then we have a question from John.
Okay, so real quick, Rachel, thank you so much for all the information. I received clemency from President Biden in December. I'm one of the Home Confinement CARES Act. And it's kind of ironic is that a week before, I had been waiting for my judge to rule on a compassionate release for 5 years, and also a 2255, and all of a sudden he ruled 1 week before I got the clemency. So the question I have real quick is that when I was released from home confinement, they gave me I guess it's called the NORA document that tells me what to do next to go report to supervised release, and there was nothing on that document. So my question is, does the clemency include supervised release or not? And so I reported supervised release anyways, because I didn't want a SWAT team to show up at my door. But and I actually showed the document to the probation officer, and he goes, "Oh, we'll have to take a look at that, but you're still in the computer." So I'd like to get some clarity on that if you have any.
Yeah, I don't have clarity on that. And I don't know if they did variable grants. Like, I don't know if they gave some people continued supervised release or not. And so unfortunately, you have to ask a defense lawyer to help you through it, or, maybe probation can tell you, but I'm not sure that they treated everybody the same. I don't know if others know, but there was some variability in treatment when he gave that first group of CARES Act grants, in the first 3 years. Some of those folks kind of were completely done, and some of them still had supervised release terms. And so I don't know how he dealt with this one. I mean, the press announcement was like, I'm giving clemency, but he didn't say exactly how that was operationalized in any given case. So it may be that he treated different people differently. And so unfortunately, I don't know. You do have to ask, whoever your defense lawyer was should be able to figure out what the grant entails.
Thank you, Gordon. We're going to go to Michael, and then we're going to ask the question that John put in chat, and then I think that's going to take us to the end. All right, Michael, you got 1 minute.
Sure. Thanks, Rachel. You gave a lot of really good information. I definitely plan on buying your book as soon as we get off this call. You paint a pretty bleak picture of how the system is, and on one side the leadership is weak and the other side is corrupt. Do you see? Does it seem fixable? Because when I look at the Supreme Court, and it doesn't matter if you're a Republican or Democrat, in my opinion, all those guys are dirty. So do you see a way? Do you see the system being fixed? I'll put it that way. Because right now it's like they're setting us up for, well, the very rich and the very poor. Basically, an oligarchy is what we're looking at with the things that are happening. You're getting rid of solicitor generals. And I'm not just picking on one side or the other. I'll say it again. Neither side is worth a damn. So I'm just saying, how do we fix it?
Yeah, so I'm not super optimistic in fixing any of the structural process things. So what I usually try to do is just figure out where within the world we're given can good things be done. Like that's my own personal motto. So, I thought there were certain things we could achieve in the Obama administration. I tried really hard to get them. And then, there was the first Trump administration. It was like, okay, this is going to be a different batch of things. And we're going to have to work a little differently here, but we could still try. And, ditto with Biden, ditto with now. And so, I would say in this administration, it would probably be using those few avenues of so Alice Marie Johnson, just to kind of give an example, I think Alice is a supremely decent person. And she got clemency from President Trump the first time around. And she's really committed to still trying to get other people clemency, for example. So Alice, it would be an example of somebody who I think is going to still try to work with this in this administration. And I think President Trump likes her. She was very grateful. And she was very helpful to him. She spoke at the convention. She showed her gratitude. And so I think there will probably be little pockets like that, he's just a who guy. And so that's horrible. I would never I can't justify that to you. Like you said, it's just awful. And frankly, Biden had that too, right? He was like, it's not good. But I think you just have to use those levers to try to get to those people to make the case for some folks. And then, if it turns out the federal is just a no-go, then, you try for reform at the local level or the state level. So, I try to never just say, it's just done. It's hopeless. Let's, binge on Netflix and hope 4 years goes by quickly. Instead, it's more like, okay, there's got to be some place where I can do something, and where might that be? And so, sometimes it's just your own local community, just telling people things. But I'm not happy. I'm not going to lie. I really feel like the clemency process has been terrible by both parties, like you said. It's not holding up the way that I think we would want any government benefit to be given, to give people confidence that it's not preferential. And it's just, it really bugs me when people follow all the rules and they file their petitions and they go through the process. Like those people should get relief. Like you can't just say, oh, but I had this big press release about all these others that I granted. No, that's great, but you can't ignore the people who follow the rules. And we've had too long of that happening.
Yeah, I did the right thing, but we let out Big Meech. So thank you. I appreciate you.
Thank you, Michael. Last question from John DeMena. He's asking about restitution reform, but why don't we just kind of broaden it a little bit, or maybe narrow it a little bit, because there's the third box on the pardon application that says remissions, and we've probably spent a couple of minutes on remissions and restitution if we could.
I have, that has been a kind of a non-starter in terms of getting a focus on it. And I think the reason has been that the pardon attorney and presidents, to the extent they've set the agenda, have focused on what they viewed as the kind of most pressing injustice. And so, for example, under the Obama administration, they prioritize people serving life sentences and decades long that amounted to life, because they only had that time, they had like 7 lawyers in the pardon attorney's office. So if you're imagining like how many can they realistically vet or think about, you triage and you think, okay, where's the worst injustice? And so it has tended to be that it's been sentence length defining that. And then, the other one, both Biden and President Obama, racial disparities. So to the extent there were sentences that had huge racial disparities, they targeted those. That's where you get the categorical drug grants and from Obama and from Biden. So all that's just to say that was their priorities and that's what they focused on. And I think, prison years, it seems worse than restitution and fines, when people are just thinking about human misery. But it's obviously horrible for people to be, under a kind of financial weight that doesn't allow them to successfully reenter and kind of is so oppressive that their life doesn't actually feel free even when they're out. Like, so there's a case to be made that should be a priority. And I think, I think you need an advocacy effort around it, though. I think there's a way, and and maybe that is the one to go with under a Trump administration. Maybe they're financially minded. They think a lot about the idea of what it means to have fiscal obligations. And I think if you found the right leading advocates for that, maybe people who were Trump donors, people who have been vocal advocates on his behalf as the spokespeople for we need restitution and fines, fees reform, remission reform. That would be my advice. That's the way I would advise someone in this administration to launch a campaign, is go get some of those people who maybe got clemency from President Trump the first time around, as who are supporters of him or grateful, and have them start to publicly, or not publicly, even just within the administration, advocate for that kind of a focus. And maybe, maybe something could get done.
Just to put my advocate's hat on for a moment, in our group, we tend to say that every sentence is a life sentence. And this is primarily the reason why, because while there has been progress in lowering actual time spent in prisons, whether through the CARES Act or the First Step Act or whatever, it's like the Lord giveth and the Lord taketh away. And so enforcement of restitution and forfeiture has skyrocketed. And so we feel like we are over prosecuted now in terms of the size of forfeitures, for example, and that sticks with us forever. So, but there are some initiatives out there within our white collar world. There's the Remissions Initiative and the Ladies of Hope Ministry. They're working on bills right now, and more good stuff to come. So, with your permission, what we'll do is we'll call upon you when the time comes, and seek your good counsel, if that's okay.
Oh, no, absolutely. Absolutely.
Rachel Barkow, thank you so much for an incredible evening. We learned a lot, and we're honored and blessed that you shared your time with us tonight.
Oh, no, it's my honor. Thank you for spending time listening to me babble.
All right, just a couple notes at the end. I did put a link to Rachel's book. It's on pre-order on Amazon. You can find that link on our website, on our social media. Please pre-order it. I have. And the name of the book again is Justice Abandoned: How the Supreme Court Ignored the Constitution and Enabled Mass Incarceration. Rachel is a professor at NYU Law School, where I'm clearly going to be applying for an LLM now, just to hear more from you. And please join our white collar support group on Monday nights. More information at our website, prisonist.org. That's prisonist like feminist.org. And Rachel Barkow, thank you so much for being with us, and have a pleasant night, everybody. Blessings, and look for this on YouTube and on our website. Thank you.
Thanks, everybody. Good night.
Thank you, Professor.